All right, Mr. Stevens, legal update.
Yes, sir. I'd like to call our interns to the table here. And first, I wanted to thank them and to bring to your attention the fact that Tori and Janelle, Janelle's from UC Davis Law School, Tori's from McGeorge Law School, were our and your interns last semester, and they both agreed to stay on with us. And
showing great good sense or something
like that. I don't know.
That.
Hopefully they're learning something,
right.
Whether or not it's what they want to do with their lives or what they don't want to do. But in any event, they're here, and I'm very thankful. And I asked them to just give a very brief, concise update on a couple of cases that are basically in the news, and asked them not to go into...
The whiz-bang cases?
Yeah, the whiz-bang cases, not to go into a lot of the technical legal jargon and the briefing schedule and all that, but just some things that caught our attention that aren't necessarily the ones that we necessarily report on all the time. With that, I'd like to turn to either Janelle and or Tori.
Ladies, who's going to start?
I guess I'll go ahead and start.
Ms. Kratliker.
Good morning. My first case I'd like to bring to your attention involves the Yuba County Water Agency's challenge to the National Marine Fisheries Service BIOP. The case comes to us out of Yuba County. It involves a BIOP that was adopted last February. The controversy is outside...
A BIOP being a biological objective.
Biological opinion, right. Yeah. So the controversy is outside of the council's jurisdiction. However, the biological opinion involved, if implemented, could have serious implications for the Bay Delta region. The Yuba County Water Agency, which I will refer to as YCWA from here on out, relies on 2 debris dams located on the lower Yuba River, and they're both owned by the Army Corps of Engineers. There's the Daguerre Point Dam and Englebright Dam. They were constructed by the Corps to contain gold rush mining debris and sediment and to control for potential navigation and flood risks. The Corps consulted the National Marine Fisheries Service regarding the 2 dams under the Endangered Species Act, and the BIOP at issue was adopted as a result of this consultation. The BIOP concludes that the proposed operations of the 2 dams would jeopardize several ESA-protected fish species, as well as adversely modify or destroy critical habitats. The BIOP asserts that the preferred reasonable and prudent alternatives to continued operation is dam removal. So the YCWA estimates that the dams contain 30 million cubic yards of contaminated debris, which includes mercury and other harmful chemicals that can have a substantial negative impact on fish habitat as well as public health in the lower Yuba River and the Delta. The YCWA estimates that the reasonably prudent alternative, if implemented, could cost upwards of $1 billion. YCWA also says that the BIOP is, quote, replete with technical errors and flawed legal analysis, unquote, and that the National Marine Fisheries Service reached conclusions based on erroneous analyses. The YCWA sought to collaboratively correct the flaws of the BIOP with the Corps and the National Marine Fisheries Service to no avail. So they recently filed suit on January 9th, seeking a declaration that the BIOP is illegal and for an injunction prohibiting National Marine Fisheries Service and the Corps from implementing the BIOP. We'll continue to monitor this case and we'll provide updates as they arise. The second case I'd like to bring to your attention is the Westlands Water District $1 billion claim that was recently rejected. Westlands Water District has a claim, or had a claim, against the federal government in the United States Court of Federal Claims, which was dismissed on January 15th. The judge rejected Westland's claim that the federal government should be liable to pay for failing to build a drainage system that would remove used irrigation water. The court cited minor technical legal reasons for the claim's failure, including an expired statute of limitations. The problem stems from the authorization of the Central Valley Project dams and canals back in the 1960s. Westlands claims that the federal government was legally obligated under several contracts to complete a drainage system. The federal claims judge reasoned that government representations are not binding contractual obligations unless stated as an undertaking rather than an intention. The drainage issue in Westlands has been longstanding in the San Joaquin Valley. In the 1980s, thousands of waterfowl were killed from selenium concentrations in the water at the Kesterson National Wildlife Refuge as a result of this toxic buildup from the lack of irrigation drainage. There are several lawsuits regarding this drainage problem that are still pending on other legal theories, and we'll continue to monitor those cases and provide updates as they arise.
At dispute was a pretty penny of taxpayers' money, I gather.
Yes.
How much?
It didn't say in the article.
$1 billion.
$1 billion.
$1 billion.
Wow.
Yeah. It was pretty interesting story. Came out 2 days ago. 2 days ago. Okay. The Sundial.
My update is related
Got to
to
get the mic closer to you.
Okay. My update is related
Pull
to
the mic down 2 inches. Got it. There you go.
How is this
He's
okay?
a choreographer, in case you didn't know. So.
Yeah.
I know.
By the way, Mr. Fiorini knows how to turn the mics on and off, as he illustrated with Ms. Gray. So he is now the only council member permitted to touch the microphone from now on. Just to let you know. Smart move.
My update is related to the consolidated fish cases, specifically smelt and salmonid. I gave you an update previously. However, today is a little bit different. You're going to hear from our lead scientist later on the fall midwater trawl, because fish populations and take limits are at the essence of the ongoing litigation. We thought we'd pose a couple of really basic questions to one of the involved attorneys, who will go nameless, to get a sense of where things stand at these smelt and salmon cases. We had a few fundamental questions about fish populations and how they relate to the smelt decision. And I'm going to relay that information to the council. These smelt cases have been driving Endangered Species Act litigation, which, as you know, is extensive. So my questions begin with: which biological opinions currently control project operations? Currently, the federal district court in both cases invalidated the 2008 smelt biop and the 2009 salmon biop. However, it did not vacate them. Since they were only remanded, operators still have to comply with the reasonable and prudent alternatives, the RPAs, until a new biop is issued or the court can rule something else. Since December 19th, this past year, 2012, Fish and Wildlife Service's 2008 smelt biop has been controlling. The first flush reasonable prudent alternative action 1 was implemented on the 19th. We're now in action 2, operating to negative 3,500 CFS. OMR, which I believe is the Old Middle River, is the controlling factor. And what was also said was that the salmon biop would allow up to negative 5,000, but since smelt is more restrictive, it's controlling. The second question was whether the Department of Water Resources and the federal agencies recently filed for an extension of the remanded biop for 3 years, and it's supposed to come out in this spring. So what would the legal effect of that be? The NRDC is filing opposition to those motions, and others are filing as well, including the fish groups who are intervening. And the argument against the extension is to avoid having continued litigation and uncertainty around the biops. The new biops that will come out, hopefully, in 2013 will resolve our issues. The next question is, the current remand schedule requires the new smelt biop at the end of this year. There are no articulated plans to combine the biops. For anybody who is interested to know, if they were combined, it would have to go through the biop process if for some reason the salmon biop affects the smelt. Otherwise, National Marine Fisheries Services can propose no jeopardy. Nobody knows how that will play out, but the salmon biop is not due until 2016. Next, other than the extension request, is there any other litigation in the district court? Currently for smelt, we're still waiting to hear the ruling that I had spoke about in our last update. We still don't have a date for that. And for the salmon, the opening briefs were completed. Replies are pending. Briefing will be complete by April 22nd, so we'll have something to report at that time. And finally, and this is based on a non-scientific understanding, I'm not obviously a scientist, based on conversations.
There are a bunch of them in the audience who are
I
going
know.
to leap up and savage you.
Exactly, so please do that if I say anything that's wrong, but I just want to give, a basic understanding of these things. And now, what legal effect will there be based on this new information that there was a decline in the fish populations this past year? The first response was that we're not sure that it would affect the biological opinions. It affects the 4 species that were showing the decline at the heart of the pelagic organisms. So we're just focusing on Delta smelt, though, which is is the only one listed under the Endangered Species Act. And from what I understood, the decline was not unexpected. It was a bad water year. But also, from a legal perspective, the biological opinions are not designed to recover, just to keep the smelt from going extinct. So that's kind of a distinction that might be surprising for some. And finally, there was an increase in the prior year in large part because of the Follex 2 action. Last year we didn't have one. So it makes more sense that we would be closer to what we were at 2 years ago. And actually, the numbers are higher than they were 2 years ago. It was 29 index value population. 2011 it was 343 because of the Follex 2 action, and then this year it's back to 42. Another comment was that longfin smelt is not listed in the Federal Endangered Species Act. The spring outflow was bad, so the decline is not surprising, and that's at an all-time low. And then the implication of all of this is that fewer fish can be killed at the pumps because of the take statement. So if there are more fish out there, then the pumps are allowed to take more. Eventually, it balances out regardless of whether it's a bad year or a good year as far as take for the projects. And we'll continue to monitor the potential effects and implications of the larger decisions, and we'll keep you updated. Thank you.
Okay. Thank you very much, ladies.